Welcome to the New Wealth Wave podcast hosted by Dr. Joaquin Wallace. We're diving deep into the intricate layers of the 7-stage generational wealth model to offer invaluable insights on legacy building, wealth accumulation and preservation, and financial growth across generations. I'm Dr. Joaquin Wallace, and this is the New Wealth Wave podcast. Hey, future wealth builders, this is Dr. Joaquin Wallace, and thank you for joining me on this new episode of the New Wealth Wave podcast. Today, we are focusing on stages 6 and 7 as we navigate ourselves around the generational wealth model. And to help lead the discussion will be Martin C. Johnson. Yes, that name is familiar. This is Martin C. Johnson, who was our first live guest on the New Wealth Wave podcast. And so it was so good, we said, why not do it again? And so we have a lot of content we're going to discover today. But before we get started, if this is your first time tapping into the New Wealth Wave podcast, make sure that you tap into the link to download the PDF copy and make sure that you subscribe because subscriptions help build the content. Now, before we get started, we always go over the 7-stage generational wealth model. So let's get started with that. So stage 1 is our internal and external ecosystem. Stage 2 is our financial genetic code, which we focus on financial trauma and financial anxiety. Stage 3, financial healing. This is where we attempt to reprogram your and our financial genetic code. Stage 4 is financial edification, where we focus on financial literacy and financial inclusion. And stage 5, that is financial well-being. That's where we want to be. We want to have a soft landing and we don't want to outlive our income. Stage 6, generational knowledge. This is where we create our financial footprints. We talk about planning because that leads us to stage 7, which is generational wealth. Again, to help lead the discussion will be Martin C. Johnson. Martin, welcome to the New Wealth Wave podcast.
Thank you very much, Dr. Joaquin. It's a pleasure being back with you.
So, Martin, you had a chance to take a look at the model itself. In the beginning stages with me, I was bouncing a lot of ideas off you with the model itself. So before you became who you are today, Mr. Esquire, attorney, where were you at on the model?
Well, doctor, it's hard to tell exactly where I was on the model. I would say somewhere between stage 2 and stage 3 before I really became an advocate for generational wealth and generational knowledge. My aha moment happened way back in the mid-'80s. I'll never forget at a 4th of July dinner, I was sitting with some other African-American men, and we were just talking about how there are other cultures who can get together and pool their monies and do things and do projects and help each other out. And I said, why can't we do that? And that was the beginning of a Black male investment club called the Onyx Group that is still in existence today. And that was kind of the aha moment for me.
So, Martin, since you've been on the podcast and since we did the episode 4, which again is the most viewed episode we've had in the infancy stages of the New Wealth Wave podcast, I've received many questions and I wanted to make sure that I covered those questions as well. So when we had the opportunity, you say, hey, let's get back on. I was like, hey, let's go for it because there are so many questions that I had. I'm not an estate planner. Obviously, I have the ability to answer some questions, but not to the extent to the level that you have. But one of the questions that people was asking me, and I heard a lot, was what is the main difference between a will and a trust?
That's a good question, and many people do ask that. In fact, I get many questions per month that specifically say, I'm considering a will, but I heard that I might, need a trust. So let's break it down, the differences between a will and a trust. A will is a document where you are setting forth your wishes on how you would like your assets distributed upon death. So a will does not come into existence as far as its effectiveness until a person dies. So although you may create a will, it really has no function until you pass away. Another use for a will is for people who have minor children to name guardians. So this is a document in which you could also name the guardians of your minor children. So when you die, that will be entered into probate court, and the probate court will go through the will, look to see who you designated as your executor, and that person would be put in place by the court to oversee the distribution of your assets. And if there's a nomination for guardian in the will, the court would go through the process of giving guardianship to that person that you name, and that's barring that there are no objections from other individuals. So the will distributes property. Now, you heard me mention probate and you heard me mention court. A will requires court supervision of the distribution of assets. Okay. So your question asks, what's the main difference between a will and a trust? A trust does the same thing. It distributes your assets upon your death, but a trust comes into legal effect the moment you execute it, because the trust is run by a trustee. And in many cases, the initial trustee is you, the grantor or the settlor, the person who creates the trust. The trust also helps in the event that you become incapacitated. There's a successor trustee that's named that will carry out your wishes. But let's just go back to in the event that you die. In the event that you die, the trustee will distribute your assets outside of court. It is a private affair. There are still rules and regulations on how the trustee may go about the distribution of your assets, but it takes much less time. It's much less expensive to do the distribution outside of court. So at a high level, that's the primary difference between a will and a trust. And I'm sure we can dig deeper as we go along.
Future Wealth Builders, it's important that you take plenty of notes because this is going to be a very informative podcast, a lot of information. You may have to go back and listen to it again, but the purpose of this podcast is to educate you in regards to the Stage 6, generational knowledge and transferring your wealth effectively. So next question I have for you is, why might someone choose a will over a trust?
Someone may choose a will over a trust if they have very little in terms of assets, particularly if they do not have real property and the assets may be what we call tangible personal property. These are things that can be picked up and moved. So maybe they have artwork, maybe they have jewelry, they have other things besides real property. And there are certain thresholds in which in California right now, the threshold is $184,500. Anything below that, as long as there's no real estate involved, there are some simplified processes for changing title and getting those assets to your loved ones. But another reason why someone might choose a will is for the main reason that it is court supervised. And if they anticipate maybe a battle of some sorts between family members and they really do not want to deal with it while they're alive, they could say, you know what, I want this to go through probate because court's going to make sure the appraisals are done correctly. The people that you're giving these assets to are the people they say they are. So there are some benefits, but the problem with probate is that it's going to take anywhere from 9 months to maybe 2 years, and it is expensive. The more assets the probate court has to handle, the more expensive the probate is, and these fees are set by the state. They are not set by the attorneys handling the probate.
So you talked about wills and trusts. So for someone just tapping in for the first time, make sure you subscribe to the New Wealth Way podcast. Kind of give us a background or a definition of what is probate and how do wills and trusts differ in this process?
So probate is the court supervised process of distributing assets that have to be retitled. So primarily real estate, businesses, bank accounts, anything that is not inside of a trust on the day you die, basically anything in your own name outside of a trust on the day you die must be probated, except for accounts that have beneficiary designations, such as life insurance policies, retirement plans, annuities, as long as you've named a beneficiary. Now, in our profession, Dr. Wallace, you know that people will maybe get a life policy and not name a beneficiary, or have an IRA and not name a beneficiary. If that happens, that account is going to go through probate in order to be distributed. So probate is a court supervised process. Now, probate happens to people who leave a will, and it also happens to people who don't leave a will. If you don't leave a will, that's called dying intestate. You have died intestate. And there are rules in every state that determine when a person dies without a will, this is how their assets get distributed. In the case of a person who's married, it goes straight to their spouse. If there's no spouse, it goes to children. If there's no children, it goes up to the parents of the deceased. If there's no parents, then it goes to brothers and sisters, and on and on. So you can imagine, if you die without a will, one of your brothers, sisters, somebody may get assets that you may not have intended for that person to get assets. So that's dying intestate. That goes through probate the same way a will goes through probate. But when a person dies intestate, the court has to name someone as the administrator of the estate. And that person may not be someone you want. And generally, it's going to be a spouse first place. If there's no spouse, it could be adult children. It may be a parent, but people can object to it. So let's say you die without a will and you are married. Your spouse goes to petition the court to be the executor, and maybe your brother comes into the court and objects to that. So that becomes a ugly legal battle. So you can see how the dollar signs start clicking and that cash register starts ringing. If a person has a will, you're still going to go through probate. But in your will, if it was written properly, you should have named a executor or personal representative, and maybe one or two backup successor personal representatives in the event that the person you name may be not around anymore, may be unwilling to do it. So it makes it much easier for the court to assign the responsibilities. But there are so many levels and hoops you have to go through in probate, and that's why it takes so long. Now, you asked Dr. Wallace, how does probate affect someone with a living trust? Well, if you have a living trust, you are not required to go through probate. There may be some instances where you may need court involvement, depending on how well the trust was written. If there's some ambiguities in the trust, you may go to court to get an opinion on that. But for the most part, a well-written trust avoids probate, and trust assets can be distributed relatively inexpensively and in a very short time compared to probate.
Question for you. So when you have clients come into your practice, they're typically at stage 6 of the process in terms of the future. So let me go back. So when we talk about the 7-stage generational wealth model, it is based upon the past, the present, and the future. So future wealth builders, let me kind of walk you through that process. So we've seen the model itself. Stages 1 and 2 is the past. Stages 3 and 4 is currently the present. And stages 5, 6, and 7 is the future. Now, depending on where you're at, particularly in your life, you may be in a present state, which is stages 5 and 6 versus in the future. Having said that, Martin, when clients come into your practice, they're typically at that moment, at that particular time, they're in their present state. What is some of the questions or some of the issues that you find when clients come into your practice looking at getting an estate plan?
Generally, Dr. Wallace, people are motivated to come see me either because they have heard about or witnessed a bad situation of a friend or a relative whose estate had to go through probate. That's one thing. Or maybe they've gotten some financial education, some financial literacy, and they've heard about estate planning and living trusts and wills. And they say, I don't know enough about it, but I think it's something I need to do. I find that people who are maybe about to get married start thinking about estate planning. People who have had children, like new children, and people who buy property. These are some of the triggers, what we call life events, that get people to start thinking about estate planning. And when they come in, the first thing I ask them is, what brings you in? How can I help you? What is it that you currently already know about estate planning? This allows me to determine whether I need to go through a mini estate planning 101, living trust 101, or, wills and trusts 101. Sometimes people come in because they've had an estate plan done and it was done years ago. They've made some changes or life has happened. And now they realize that this person is no longer living. I need to replace them in my estate plan. So these are the things that get people into the office. I think some of the things that keep people from coming into the office are myths and fallacies and things that they've heard about, the trust. It's expensive. You got to have money to have a trust. And when people, who are good earners, but maybe they don't own a lot of property, they have one house, they're like, that's not for me. I'm not wealthy. I don't make a lot of money. But as we discussed in a previous episode, here in California, if you own a home, most likely that house is worth at least $500,000. And that's worth you coming in and getting an estate plan done, because I'll tell you, a $1 million estate is going to cost about $46,000 to go through probate, and it's going to take about a year. Whereas that same person, if they incorporated a living trust into their estate plan, they would avoid probate, and the trust could cost them anywhere from $1,500 on up to maybe, even if it was $10,000, they're still going to save time, money, and heartache if they come and get estate planning done.
And just to follow up on that, when that person does pass away and it's not an estate plan, as you mentioned earlier, it goes into probate. One thing that you have to consider is that the mortgage still needs to be paid at that particular point, right? And that's oftentimes how the property is not transferred, because the mortgage isn't being paid as well. So that's important to kind of point that out. Yes, we do need to have everything in an estate plan. And that's the importance of doing, as you mentioned earlier, it can take some time. But during that time, there still needs to be a payment in regards to the mortgage. And that's where, when you go into, you mentioned earlier about the beneficiaries, you find this all the time, well, more times than not, when individuals don't change their beneficiaries. And so you may have been married at one point, you may have blended families, and the beneficiaries haven't been changed. So the first spouse may be the main beneficiary. So that affects what goes on with that current relationship, because those life insurance proceeds do not go to the current spouse. It goes to the beneficiary, maybe the beneficiary kids and whatnot. So it's important that people understand and realize that you have to stay on top of your beneficiaries. And Martin, it may have happened, as you mentioned earlier, they may have had a job 15, 20 years ago, have 401k plan, still being held by the TPA, the third party administrator. They may not have rolled it over into the new job or put into some sort of managed account of their own. So those funds are still there. And when that person passes away, those monies will go to beneficiaries that's listed on that particular account. I'm glad you mentioned that, because that is so important to realize that we try to take for granted. So we talked about the cost, of wills and trusts. What's more expensive, a will or a trust?
Well, when you first look at it, the trust is definitely going to be more expensive than a will. You could probably get a will done. I mean, people could do wills themselves. In California, we have what's called a holographic will, where a person could do a handwritten will. As long as it's totally handwritten and signed by them, no witnesses are required. That can be done on one sheet of paper. But what tends to happen in those cases is that people don't address several things. And I'll give you one prime example. If you do not address whether or not you're going to require your executor to be bonded or not, that will goes through probate, and the court is going to require the executor to get a bond. And the bond is going to have to equal or exceed the estate value. So if there's let's just say $800,000 house involved, and you did a handwritten will, or you did a will yourself online, and you did not have the requirement for no bond, and you name your brother as executor, the court says, okay, brother, you need to get a bond for $800,000. Your brother has bad credit. He tries to get a bond. No bonding company is going to issue a bond. Okay. So now the court's going to say, well, you cannot be executor. So we now need to get someone else in here. And lo and behold, it's your cousin that you can't stand from, 20 years ago. He comes in, the court says, okay, you can be the executor. And, you have to prove why you should be the executor and that sort of thing. But if that cousin can get a bond, that person's going to be the executor of the estate. So I say all this to say you can get a cheap will, but is it going to serve you? No, it's not. So on the upper end of the spectrum, a will might cost $700 or $800, depending on what's in it and the provisions and whether it's done by an attorney or not. A trust could also be done online. It's going to be about 6 pages long. It's not going to have nearly the number of provisions that a good, well-written trust should address, but you might get that for $300 or $400. But is it going to serve you when it doesn't have the provisions that are needed? I'll give you an example. So I saw a trust that was 6 pages long. The woman had died. A year later, there was still money in a bank that hadn't been transferred to the trust, and the successor trustee died. So not only did the original grantor die, her successor trustee died. And so here's the beneficiary trying to get money out of this particular account. And the bank would not deal with the son who was left because the trust did not address what would happen after the successor trustee died. So we would have to go to court to have a trustee appointed for that trust. So if you're having a trust done properly, you got to expect to pay. Like James Brown used to say, you got to pay the cost to be the boss. And B.B. King had a song, you got to pay the cost to be the boss. So if you want to be in charge and you want to be financially literate and have some generational wealth, it's going to cost you something. So you may pay $3,000, $4,000 for a properly drafted trust. So that gives you an idea of the cost from zero into the mid thousands versus probate that's going to easily start at around $23,000, $24,000 and go on up.
You mentioned the word bond. For our listeners out there, could you kind of just give a brief definition of what does bond actually mean?
A bond is an insurance policy that basically says we're going to ensure that this person does right by the deceased by making them go out and get this bond. The bond company writes a policy so that if this person runs off with the money, the bond will pay the money to the estate or to the court while the cops go after the person who did wrong by the estate.
So when we talk about the information in terms of estate planning, it's always a point of emphasis that you have to make sure, I make sure that when I meet clients, one of the first questions that I asked them during my fact finding, do you have an estate in place? And I would say it's a large portion of individuals that don't, because it goes back to some of the things that you mentioned earlier. Fear is one. People don't like to plan for their demise is another. Cost, things of that nature. But for the most part, it's something that you have to place within your portfolio because, once it's done, it's done. It's done. You don't have to go back and do it all over again. I'm going to ask you a question in regards to that. Once the estate plan, you've drafted it, everything has been sent to the state of California, you give them their book, if you will. It's a green book. It's a beautiful book. Actually, Martin does take a picture with you as well, puts it on his website, kind of promotes it. But once all of that is done, what's the process if someone wanted to make some changes to their estate plan?
A good question. First of all, I do want to clarify that once your estate plan is done, the documents you receive, there are multiple documents. Some of those documents you will be sharing with other entities, such as your healthcare provider, maybe your bank. We retitle mortgages into the name of the trust. Other than that, your trust is a private document that stays with you because people often ask, well, what do I do with it when it's done? Do I have to register it someplace? No, you don't have to register it with the county or the state. That would defeat the privacy of a living trust. But to answer your question, yes, these documents can be changed, particularly with revocable living trusts. Revocable means it can be amended, it can be changed, and it can be revoked. or basically, torn up for lack of a better word. The same thing can be done with a will. Depending on how early in life someone put their estate plan together, you can imagine that there are going to be changes throughout life. There's going to be new children born. There's grandchildren that come into the picture. There's going to be deaths. People are going to start acting crazy, and you may not want them in your estate plan anymore. So the trust is written in such a way, yes, it can be amended depending on the number of changes and the types of changes. The cost is going to vary. With most people who want to change their will, my recommendation is just to create a new will. There is a technical term for changing a will. It's called a codicil. But, if it's been 5-6 years and someone's died and you don't want their name in your will anymore, I would just say, come on in and get a new will, because the cost of a change is almost going to be the same as a new will.
Future Wealth Builders, make sure, again, that you're taking notes, stopping the podcast, rewinding it, because, again, a lot of gems are being dropped by Martin Johnson. And again, this is part 2. I would say, Martin, maybe part 2, an extension of the first time. If you haven't had a chance, go back to episode 4 of the New Wealth Wave podcast, and we kind of give an overview of estates and things of that nature, a really comprehensive overview of the process of financial planning, which is generational knowledge. And today we're kind of diving back into that as well. So make sure that you hit the subscribe button. So you mentioned a revocable trust and the irrevocable trust. Again, so for our listeners that are out there, could you give a brief description between the difference between an irrevocable trust and a revocable trust?
Yes. Irrevoke means you cannot revoke. And so someone may say, well, why would I want to create a trust that I can't change or revoke? And there are some very valid uses and reasons why a person may want to create an irrevocable trust. First of all, the tax code allows many tax benefits for moving assets to an irrevocable trust. The number one benefit is that it takes the property out of your name, and thus it takes it out of your taxable estate. Now, most people these days are not going to be faced with estate taxes. Nationwide, it's $13 million that you can leave to someone estate tax free. But as we know, there are some very wealthy folks, and let's say they have $15 million of estate assets they want to leave. Using an irrevocable trust, they could move $3 million of assets to an irrevocable trust, gets it out of their name, and that's going to reduce their taxable estate from 15 million down to 12. That brings them below the estate tax level. That means that 12 million can go to their heirs estate tax free. And that 3 million that moved over into the irrevocable trust, that is not going to have any estate taxes because it's now out of that person's name. And that can go to heirs as well, estate tax free. What you give up with an irrevocable trust is you pretty much give up control. You cannot be the trustee. The trust cannot be changed. So you're giving up a lot. But, people do this all the time. And there are some ways to kind of have some tangential control, but that's beyond the scope of today's session. With a living trust, it's revocable and it can be changed. So those are the two differences, revocable and irrevocable. Irrevocable cannot be changed. Revocable living trust can be changed.
Appreciate that. So that 14 million that I have, I need to go ahead and move that to an irrevocable trust then.
You need to move some of it. We can set up a trust. You can move some of that to me.
I appreciate that. So I'm sure my beneficiaries will have a lot to say about that as well.
Yeah.
So this thing about long-term care, and so Future Wealth Builders, make sure that you listen to episode 8. We have just an entire session just based upon long-term care and how that needs to be a part of your planning model, so to speak. But there's some confusion around whether a person would have to spend down their assets before being eligible for Medi-Cal, which many people use for long-term care. Could you kind of explain the ins and outs in regards to that?
Well, first of all, I think we should address the fact that long-term care is the phenomena of the fact that we're all getting older. And if we get old enough, we may be at a point where we cannot care for ourselves and we cannot perform the activities of daily living, cooking, cleaning, transferring, that means moving from bed to chair, chair to bed, toileting. So when you get to a point where you cannot do 2 out of 6 activities of daily living, you're pretty much disabled and you need to have someone caring for you. Traditionally, a lot of that was done in the home by a spouse or a family member or someone. But as people are living longer and longer, staying in the home may not be an option. So what happens is they tend to try to find a nursing home. And we're talking about people who don't have the assets to just go and spend, $10,000 a month on an assisted living facility. So many people, the solution of last resort is a nursing home paid for by the county that they live in or the county that the nursing home is in. And, you're talking $4,500, $5,000, $6,000 a month. And if you don't have the resources or the assets, the county will pay for this for you. But up until January 1st, 2024, there was an asset limitation. If you had assets over a certain dollar amount, you would either have to have spent those down, and there was a 3-year look back, 5-year look back in some cases, or you would have to get rid of those before you could even apply for Medi-Cal and this nursing home benefit. The other issue was that if you had a home and you went into the nursing home, as long as you intended to come back home, that was cool. You could still be eligible, but you could not have a certain amount of income. So with the new rule that took place January 1 is that as long as the assets are not in your name, that means those assets could be in a living trust, then Medicare has no what they call recapture provision, where they would try to go and get those assets after the person has died who had been on Medi-Cal for 2-3 years in a nursing home. So the new law says there's no asset limitation. So you can have a $500,000 house or $1 million house, but it should not be in your name, because if you die and it's still in your name, there is still a provision to come get those assets. And what they're going to do is recoup the money they spent on your care while you were alive. So the rule is, if it's not in your name, it can be in a living trust. But if it's in your name, that means, you've gone to the nursing home, you didn't move it into a trust, and it's considered a probate asset, it is still subject to recapture. But the eligibility to go onto Medi-Cal, there is no longer an asset limitation. So unlimited assets, but its income is the driver. And I think the latest figure is about $3,854 a month. If you make more than that, it's going to be tough to qualify for Medi-Cal nursing home benefits.
Yeah. So my question to you, and that's great information. That's why it's so important to have these discussions, right? Because oftentimes they are not had before it's too late. So one thing that I've taken away from this discussion, one, make sure that your property, anything that you own is in an estate. That's important, because then it cannot touch you in that situation there. It's not considered yours. So in terms of what we're speaking of, it doesn't put a limitation on you. So that's the first and foremost. When you talk about the income and things of that nature, I love how you tied it in with income. So my next question to you is this. We know Social Security, we know what that's considered, but does that income also include an annuity that you may have, some sort of retirement plan, 401k that's paying into it? Is that considered an income as well?
Yes, the income is considered once the income comes to you. So if you're living off of distributions, if it's coming from an annuity, if it's coming from a retirement plan other than a Roth IRA, if it shows up on your tax return, it's considered income. So, because the goal is they don't want somebody who's sitting on $10,000 a month in dividends coming in to be able to have the taxpayers pay for long-term care. So you could see if you're down at $3,800 a month in California, that's not a lot of money. So the program is meant for indigent people who really, it's a last resort. They need the government to cover their long-term care.
Great information, future wealth builders. I mean, that's a game changer to know that, because California, I believe, is one of the only states that do not have those limitations. Depending on what state you're in, the rules and law is different. So another question in regards to this, how does a trust work to manage assets for minors or dependents?
Excellent question. Let's say a couple comes in, they have 3 kids, and they've named these 3 children as beneficiaries. And mom and dad are on vacation. Unfortunately, the plane goes down, and you now have 3 children with no parents. But because the parents put a living trust in place, they've named a successor trustee who could be a professional fiduciary or a trusted family member. And if it was a well-written, well-drafted trust, there's going to be provisions on the care of those children using the trust assets. And if they are minor children, the trust should allow for health, education, and welfare. And at certain ages, distributions of trust assets could be given to the minors. So you may say, up until they're 18 years old, we're going to pool this money and we're going to call it a pooled trust for the benefit of the kids. After 18, if one of the children wants to go to college, the provision allows the trustee to pay for tuition. If another child wants to go to vocational school, it can pay for that. If the other child just wants to sit around and be non-productive, if it's well written, it could say the only thing the trustee is to do is make sure there's a roof over their head and clothing, but no other cash is being distributed. So the trustee, based on the way you want your kids treated and raised, will follow those directions in raising and managing the money for those children. Now, this is another area where people are hesitant to come in and even learn and talk about it, because they'll say, well, I don't trust that so-and-so will follow the provisions of the trust. And, the issues are, well, first of all, we need to find someone that you do feel will carry out the provisions. And maybe that is a professional trust company or a professional fiduciary. But the state of California, the probate code will enforce the provisions. They are held to a fiduciary standard, and they must be looking out for the best interests of the beneficiaries. So there are some laws and guidelines in there to help enforce the rules of the trust. And then the fiduciary responsibilities mean that the money has to be invested prudently. It just can't be sitting in a bank account earning, 2% interest. It should be diversified. It should be growing so that the beneficiaries do benefit from proper trust management.
Another question for you. We've been speaking about trust throughout the session. What's the difference between a living trust and a regular trust?
Well, most people, when we talk about estate planning, a regular trust and a living trust can be synonymous. Both of them are revocable. So sometimes you'll have in the official title of a trust, it may say the Wallace Family Trust. Someone may want theirs to say the Wallace Living Trust. There's no difference in how they function other than the provisions inside may be different. But as long as they're revocable, they're pretty much going to be the same basic kind of trust.
Here's a question I get a lot. Can a trust protect assets from creditors?
Yes and no. Once again, you said a trust. So an irrevocable trust, if you transfer your assets into an irrevocable trust, remember, irrevocable, you lose control, but the assets are in there for your beneficiaries. If you then get sued, your creditors cannot access those assets that have been moved into an irrevocable trust. Any assets in a living trust, for you, the grantor, the person who put the assets in, the person who is now the current trustee and you're managing those assets, if you get sued, a creditor would be able to access those assets. The easy way to remember is if you can get to it, your creditors can get to it. Now, that same trust, if you are out of the picture and one of the beneficiaries gets sued, that beneficiary's assets are protected because the beneficiary does not control the trust. They are just a recipient of the assets of the trust. And the trustee has discretion as to when those assets go to the beneficiary. So if your son or daughter is a beneficiary of a trust and they get into an auto accident and it's their fault, and the plaintiff finds out that they are the the beneficiary of a trust, there's not much the plaintiff can do to get to those assets. But once the money is given to your son or daughter and it lands in their bank account and it becomes their money, then one of their creditors can access those assets. Obviously, they have to go through court and get a judgment, but yes, they would be susceptible.
That is great information. I mean, again, we're unpacking, we're dropping tons of gems on this session. Martin, should I just say this is part 2?
I guess you could say this is part 2, but as you and your audience probably realize by now, there could be part 3, part 4, because right now we're just talking about trust and will. There's so many other documents that are a part of the estate plan that we addressed in our part 1, but it was your episode 4.
Leading into that, you are a friend of the program. You are a resident expert. We definitely will be bringing you back. We probably have to do this like once a quarter, right? To get some more information, kind of refresh. Again, if you missed the first episode with Martin, that's episode 4. It's the most viewed episode we've had thus far. And we kind of get a kind of an overview of the New Wealth Way podcast with Martin, which is a great episode itself. So here's another question I get, Martin. How are digital assets handled in wills and trusts?
Another great question. Digital assets are becoming more and more prevalent. I was speaking to a gentleman recently who was the trustee of his friend's trust. And he said, Martin, when this gentleman died, I had no access to any of his online stuff. And bills were coming due. I couldn't tell who needed to be paid, who didn't need to be paid. I didn't know if he had a Facebook account, all of these things. So one of the things that I'm really a big proponent of is creating and having an emergency binder that addresses the issue of all of these digital accounts that we have. So let's go back. First of all, to answer your question, the trust that I draft, there is a section on trustee powers, having power over all of the digital assets of the grantor. So if you end up passing away, your successor trustee would have the ability, using the trust document, to access your digital accounts. Now, of course, there's documentation that has to be sent to the website or the provider to grant you access. There's big confusion between an actual digital asset accessing the account versus ownership of the underlying account. So let's say you have a Chase, you have online access, but the bank account is not a digital asset. The bank account is a bank account. Online access really is not an asset. It's just the ability to access it. So there are people who are confused between a digital asset and access to a digital account. But cryptocurrencies would be considered digital assets. Your Facebook account is a digital asset. Your Snapchat, your IG, Instagram, those are digital assets. And one of the things that I provide in my electronic emergency binder is a way for people to list their account, their usernames, and their passwords. And we instruct people to keep the passwords in a safe place, but the usernames and the account information could be kept in your estate binder so that if someone passes away, at least they could go to the binder and see, oh, he has PG&E, he has Travis Credit Union, he has this, and they'll see the usernames, but the passwords should be in a safe deposit box or a safe. And only the person who's going to succeed you after you die should have access to those two places. One other thing, Dr. Joaquin, there are some digital services online where you could designate someone to be your successor for all your passwords in the event that you do not respond within a certain number of days of your trusted person asking for access. So for instance, in my case, my daughter and my wife have been designated as the people to gain my passwords. If I do not respond after 14 days from a request from my wife or daughter asking the password holder to release those passwords, they will release after 14 days, assuming I'm either dead or I'm in the hospital. Either way, after 14 days, I want my wife and daughter to have my passwords.
Yeah, future wealth builders. I mean, now that's something that I didn't know. Again, you kind of learn something new each time you watch the New Wealth Wave podcast. And again, I hope you're taking notes. And as I always say, I mean, this is information that you continue to share it with your friends and family, because this is critical information in regards to generational knowledge and reaching generational wealth, creating your financial footprints. So again, make sure you subscribe to New Wealth Way podcast. Make sure that you share the information as well, because this is relevant information. It's evergreen topics. It's evergreen information that will always be in play. So final question for you. What role will a pour over play, the pour over will, in conjunction with the trust?
The pour over will?
Yes.
Yes, the pour over will is for lack of a better term, it's a catch-all strategy or document for people who have created a living trust. The pour over will is there in the event that they buy something or they have an asset that has not been transferred to the trust by the time or the date of their death. So the example I always use is that you and your wife, you've created a living trust, you've moved your primary residence into the name of the trust, you have a rental property you moved into the name of the trust. But lo and behold, you guys go to Hawaii and you fall in love with this timeshare that actually has the ability for you to title this timeshare, the 3 weeks a year, into your name. For one reason or another, they don't put it into the name of the trust for you, or maybe that's something they tell you you have to do on your own. And then you come back to California, you forget all about it, and Lord forbid you have an accident and you both die. Having the pour over will allows us to tell the court that even though that property was not officially in the trust, the pour over will directs the personal representative of the will to put that asset into the trust. It does require us to go to court, takes a couple of weeks, but at least it's better than having that asset go through probate. And that's what the pour over will does for you.
So Martin, what do you want the listeners to take away from this particular session on the New Wealth Way podcast?
What I'd like your listeners to take away are a couple of things. One is you can tell from this session and our last session that this is not something you should be dabbling in, the DIY approach. You just have to pay the cost to be the boss. And the cost will vary depending on the complexity of your situation. You may be able to get this done for less than $2,500, and it could be a solid plan for you. But fast forward 10 years, you've grown assets, you have a better job, you have 5 kids now. Maybe it's time to go get a professionally curated estate plan. The next thing I want your listeners to walk away with is there's this misconception that estate planning is just a set of documents. And I hope, as you can tell from this discussion, a lot of the consulting and advice that goes into the planning is what you're paying for. Anybody can print documents, but you need a trusted advisor there to help you walk through and answer some of these questions, some of the nuances of how I should title this. What about if I name this couple as guardians and they get a divorce? Okay, who do you want your kids to go with? Have you thought of that? What if you're elderly when you have your trust first designed? Maybe you should name a co-trustee right now versus waiting till you get much older. There's a lot of things an attorney can do, a financial advisor can do to really help you craft the right plan for you and not do a cookie cutter approach. So that's what I would want to leave with your audience.
Future Wealth Builders, you heard it here. This was an impactful podcast. Again, a lot of nuggets. I hope that you stop, rewind, take notes, go back again, and ask the questions. Have these discussions in your family as well, because they are important. And most importantly, if you don't have an estate plan in place, will or trust, make the appointment, meet with someone to help direct you with that as well, because it's so important in putting it into your actual plan itself, which is stage 6. So Future Wealth Builders, this has been an outstanding episode with Martin, dropping tons of nuggets. I hope that you rewind, go back, rewind again, and have this discussion in your home because it's important. Share the material, have a family discussion, because again, we have to bridge this gap because we see oftentimes and not that we're not able to transfer our wealth because of lack of knowledge. And we know generational wealth begins with generational knowledge. Martin, we'd like to thank you, the New Wealth Way podcast, on behalf of my producer, Ray Haycraft, myself included. We'd like to thank you coming on again. And we're going to see you again. I think we need to just make this a quarterly event, our resident estate planner, because you have so much information. But again, until next time, we know that generational wealth begins with generational knowledge. We'll see you next time on the New Wealth Way podcast.
Thank you for joining us on the New Wealth Way podcast, hosted by Dr. Joaquin Wallace. Our show is edited and produced by Ray Haycraft. To dive deeper into the world of financial wisdom and learn how to create your financial footprints, head to our website at www.drjwallace.com. For more updates and exclusive content, connect with us on social media by searching Dr. Joaquin Wallace. And if you have questions and comments, feel free to email us at thenewwealthwaypodcast@gmail.com. Remember, generational wealth begins with generational knowledge. And as always, thanks for listening. The content presented in this podcast is strictly for educational purposes and should not be taken as investment advice. The views and opinions expressed by our guests may not necessarily reflect those of the New Wealth Way podcast and its host or producers. Listeners are urged to exercise discretion and judgment before making any financial or investment decisions. Always consult with a financial professional or advisor before taking any action based on the content of this podcast. If you're enjoying the New Wealth Way podcast, we appreciate if you leave us a review. We're always open to topic suggestions and guest recommendations. Feel free to reach out to us directly with your thoughts and feedback. Thank you for tuning in, and we'll see you next time on the New Wealth Way podcast.